And it's not just that you're using drugs. I mean, we've got deliveries, we've got possessions with intent, we've got fleeing from police, we got fleeing from the police in a car, hitting another car. Yeah, sentencing, probation violation, sentencing in 3 files, 22-6457, 23-6764, and 23-6765. Counsel, you want to state your appearances, please?
Melissa Goodrich, Boone County Prosecutor.
Jeremiah Buffalo, Ward on behalf of Mr. Sayers, who is seated to my right.
Okay, and have you had a chance to review the probation violation report?
Yes, Your Honor. We reviewed it some time ago. The court had been setting these matters out due to Mr. Sayers' other pending matters that are presently here in Sheboygan. We would ask that the court continue to hold that out so we can handle those other matters.
And my only problem with that is now it's alleged that he's committing crimes while he's in our jail, so I'd like to get him out of our jail. So I'm going to proceed with sentencing today. It's noticed for sentencing today. Any additions or corrections to report?
No, Your Honor.
Ms. Goodrich, any additions or corrections to report?
No, Your Honor.
Or anything you want to say on Mr. Sayers' behalf?
This is a key moment. The defense is leaning heavily into the addiction narrative. And to be fair, addiction is a real, legally recognized factor that can impact sentencing. But Judge Gauthier's immediate reaction speaks volumes. He's not dismissing addiction. He's saying he already tried the most treatment-focused approach the court has. Recovery court is not a casual program. It's structured, intense, and requires constant compliance. Walking away from treatment, abandoning supervision, and collecting new felony cases is the exact opposite of what the program is designed for. Here's something to think about. Should repeated walk-offs from treatment still allow for another shot? Or does there come a point where public safety has to outweigh rehabilitation? Drop your opinion below. This is one of the biggest debates in modern sentencing.
Yes, Your Honor. Mr. Sayers is a victim of addiction, Your Honor, and addiction rears its head in many ways, and it has got a hold of Mr. Sayers. Your Honor, I believe that the best possible solution for Mr. Sayers is to be engaged in treatment, and we would ask.
I think so too. And so I sent him to treatment, and he walked off and absconded. So I don't know how to get him to treatment. I agree 100% with you. The problem that we have is that Mr. Sayers doesn't agree with you or me.
In my conversations with Mr. Sayers, Your Honor, he does. He acknowledges that these acts that are alleged are tied to an addiction, and he needs the help. So, Your Honor, we would ask that the court fashion a remedy that allows for rehabilitation as opposed to punishment.
Thank you, Mr. Sayers. It's not required to say anything today, but it is allowed. Is there anything you want to tell me?
I'd just like to say that what he said is 100% accurate. I do struggle with addiction. I definitely need help. I want the help.
The prosecutor's breakdown here is devastating to the defense's argument. When the state lays out the timeline, prior felonies, missed opportunities, warnings ignored, and then the kicker, a new case filed the same day he was supposed to start recovery court. That's incredibly damaging. Courts rely on demonstrated effort, not verbal promises. And Judge Gauthier isn't hearing, "I'll do better." He's hearing a pattern of words not matching actions. Then comes the bombshell, another warrant request for new conduct in jail. This is where public perception divides. Some people will sympathize, seeing a person deeply trapped by addiction. Others will argue, if you're still committing crimes while locked up, what chance do you have on the outside? What do you think? Is this addiction's grip or pure disregard for opportunity?
I mean, obviously I've struggled with trying to get there, trying to do it myself. But I have 2 kids that definitely need me, family that needs me. I'm disappointed in myself for everything that I've done. I want to do better. I guess that's all, Your Honor.
Let's go to recommendations from the people.
Yes, Your Honor. The defendant is 26 years old. He had 2 prior felonies and 6 prior misdemeanors before these cases. He was given a second chance by entering to recovery court, despite numerous warnings about taking it seriously and being ready for the program. Mr. Sayers has repeatedly said one thing and done another. He had made little to no effort during his time in recovery court, actually incurred another case upon release from jail to start recovery court. And now I received a warrant request today for conduct while in jail, waiting the sentence and having the other felony court case pending. So I'd ask the court to follow the recommendations. Thank you.
Thank you, Mr. Sayers. Please stand for the court sentence. All right, so we're here for sentencing on probation violation in file 6457. You were on probation for resisting obstructing police by fleeing on foot from the police during a traffic stop. It's maximum 2 years. File 6765. You're on probation for fleeing and eluding third degree habitual second, 7.5 year maximum. In that case, you fled in a car during a traffic stop, striking a police vehicle. Both high risk behaviors. In file 6764, you're on probation for delivery of methamphetamine, drug double, maximum 40 years. Possession with intent to deliver methamphetamine, drug double, maximum 40 years. Possession with intent to deliver cocaine, drug double, maximum 40 years. I mean, I've given you so many warnings, and we placed you in the recovery court program despite some of this high-risk behavior.
This is the moment everything shifts. Judge Gauthier begins stacking multi-case sentencing, and you can hear the change in tone. He's moved from patient explanation to decisive action. Notice how he goes file by file, offense by offense, breaking down which charges carry 2 years, 7.5 years, 40 years, and how habitual status and drug double enhancements give him the discretion to extend the maximum penalties. This is crucial legal context. Judges often have 2 layers of discretion, the guidelines range and the statutory maximum. Here, he chooses not to double the guidelines, but does double the statutory maximums. That's a signal. I'm giving you the top of the guideline bracket because you didn't just fail probation, you blew every opportunity. This part may surprise you. Even with all these long sentences, the judge ultimately makes them concurrent, meaning they run at the same time. Do you think that's fair? Should they have been consecutive?
You had multiple violations. We sent you to treatment, and you left treatment and then absconded supervision and had to get arrested. That's not even taking into account that it's alleged that you've committed more than one felony while all that was going on, or while all this case has been going on. Even laying that aside, you've been just out of control, and we have tried to give you every treatment tool in our toolbox. You know, so now I got to reach for the other tools. You know, what your attorney's saying is a great pitch at the initial sentencing, and I bought it, and I put you in recovery court. And you and I have had several conversations, you and Mr. Fagan, you and Nicole. And I don't know why it just isn't sinking in. And it's not just that you're using drugs. I mean, we've got deliveries, we've got possessions with intent, we've got fleeing from police, we got fleeing from the police in the car, hitting another car. They're high-risk behaviors. It places people in danger. Not just you, it places other people in danger as well. So taking all those things into account, in file 6457, I'm going to, that's an advisory guideline range of 0 to 11 months. I'm going to revoke your probation and sentence you to, let's see, you have another 85 days credit, I think, because we've been adjourning this. So I'm going to order that you serve 284 days jail, give you credit for 284 days previously served. Any fines and costs that were previously assessed remain due and owing in the amount of any unpaid balance. That's 6457. In file 6765, that's the fleeing and eluding, 3rd degree habitual second. The advisory guideline range is 10 to 28 months. I'm going to revoke your probation and commit you to the Michigan Department of Corrections for a term of not less than 28 months, nor more than 7.5 years, exercising my discretion under the habitual offender statute to increase the statutory maximum to 7.5. Give credit for, by my count as of today, 225 days credit. Any fines and costs that were previously assessed remain due and owing in the amount of any unpaid balance. And that is a sentence within the advisory guidelines. In file 6764, on the count of, well, I'm going to revoke your probation and any fines and costs and any remain due and owing in the amount of any unpaid balance. For the delivery of methamphetamine charge, the advisory guidelines are 51 to 85 months. The drug double would give me the discretion to double that to 102 to 170 months. I'm not going to exercise my discretion to increase the guidelines, but I am going to exercise my discretion to increase the maximum penalty under the statute. So for that case, Mr. Sayers, I'm going to commit you to the Michigan Department of Corrections for not less than 85 months, nor more than 40 years.
This is one of the harshest, yet most meticulously justified sections of Judge Gauthier's sentencing. He walks through the math of each drug offense. 85 months to 40 years here, 10 to 40 years there, upper end guideline decisions, and multiple statutory maximum increases. What's important is why he's doing it. He says it plainly. Repeated violations, abandoning treatment, absconding from supervision, and high-risk behavior like striking a police car. Judges do not escalate to this level unless they believe the defendant poses substantial risk to the community. And Judge Gauthier says just that. I've given you every tool in our toolbox. Here's a question for you. Do these long sentences help someone battling addiction, or do they simply remove the risk to the public? Comment what you think. This case splits viewers right down the middle.
With credit for 225 days previously served. That's a top end of the guidelines without the drug doubling. I believe that is proportionate given his absconding supervision and leaving treatment. And again, I'm not exercising my discretion to double those guidelines. I'm leaving them undoubled, but at the top end. I am exercising my discretion to increase the statutory maximum from 20 to 40 years, however. On the count of possession with intent to deliver methamphetamine with the drug double, the advisory guidelines are 72 to 120 months. I would have it within my discretion to double that to 142 to 240. I'm not going to do that. However, because Mr. Sayers walked off of treatment and absconded treatment court supervision while all of this was going on, I'm going to sentence him to the upper end of the undoubled guidelines and commit you to the Michigan Department of Corrections for not less than 10 years or more than 40 years. Credit for 225 days previously served, increasing the statutory maximum by the drug double statute. And on the possession with intent to deliver cocaine, drug double 40-year maximum, advisory guidelines 10 to 23 months. I'm going to not double the guidelines within my discretion, but sentence you again at the upper end of those guidelines at 23 months to 40 years. Credit for 225 days previously served. Exercising my discretion to increase the statutory maximum, however, not increase the guidelines. And again, top end of the guidelines is certainly proportionate in this case. All right, and Mr. Sayers, you have the right to file, you are able to file an application for leave to appeal if you wish on any of these cases. If you want a lawyer, I give you one, but you have to ask me within 42 days. So we're going to hand you some paperwork explaining that process. One copy is for you to sign. If you want to take an appeal, the other one, we're going to ask you to initial one in all three files so that we have a copy of it. And then we'll just have to writ them out or do it by video to deal with the pending cases, but I'll not have you in our jail any longer, sir. Good luck. All those sentences will will be concurrent to each other, which I think is required by law on those files, but they're all concurrent to each other, all accounts, all the files.
So, here's where everything lands. Judge Gauthier revokes probation across all files and imposes a series of major Department of Corrections sentences. Despite the high numbers, he orders everything to run concurrently, meaning the defendant will serve the longest of the imposed terms, not each one back to back. He also informs the defendant of his appeal rights and makes it clear that jail time in the county facility is over. This case is a powerful example of the tightrope judges walk, balancing rehabilitation efforts with community safety. Judge Gauthier clearly felt he exhausted every alternative before turning to long-term incarceration. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.